please. Dr. Adesh, are you hearing my voice?
Yeah, yeah.
Adesh
I'm
ji.
listening to you, sir.
Adesh ji. Okay, Adesh ji.
Give a very good afternoon to all of you. And first of all, I congratulate to Dr. Yogen Kumar Verma ji, Head Department of uh, Department of Law, Patna University, and coordinator of this refresher course for organizing such a nice academic activity. I express my deep sense of gratitude to the UGC HRDC as well as Yogendra ji for inviting me in this August meeting and express my views regarding the topic protection of human rights of children and international perspective. Before I start, uh, I would like to share some slides before you. And I hope my slide is visible. Is it
No,
visible, sir?
sir. No, sir, it is not visible.
It is not visible. I have shared the screen.
Not visible.
Huh? Now it is visible, no?
Yes.
Not visible. Oof. Still, it is
Sir,
not visible.
kindly check the device by which you are displaying your slide.
Yes, sir, you're audible.
I'm audible, very good, but my screen is not visible, no?
No, sir.
Okay. Okay, so I start. Unfortunately, the screen is not visible or PPT is not showing to you. So I will share my PPT later on, है with the Yogen Verma sir, and it would be available to all of you. Uh, Before I start, I would draw your attention regarding some quotations which has been delivered by great thinkers and great philosophers for the protection of child. You all know the poet John Milton, and once he said about the children that child shows the man as morning shows the day. Na? Means children is the future of any nation or any country, and as the morning shows the day, in the same manner the child shows the man. The child shows the whole culture of the country, that what is the development of civilization of that country. Once a novel laureate Gabriel Mistral said that we are guilty of many errors and faults. What our worst crime is abandoning the children and neglecting the foundation of life. He said that many of the things can wait, but the children cannot wait. And why he cannot wait? He justified that right now is the time his bones are being formed, his blood is being made, and his senses are being developed. To him, we cannot answer tomorrow, and he said that his name is today, means the children lives in today. We cannot foster their need, we cannot cater their need, we cannot take security peace of those children tomorrow. We cannot answer him tomorrow because his name is today. Even Pandit Jawaharlal Nehru also said that who lives if India dies, and who dies if India lives. So if our children are not cared, not protected, not nurtured, not taken in the well-being manner, in that case, who lives in the India when the children are dying, or who want to die if the children are India are growing? So these are the things which shows that the children and the childhood across the world is known as the golden age. And the meaning of golden age is innocence, freedom, joy, play, and likewise, है ना? Hardly any children shoulders any responsibility or any obligation, है ना? Life is no limit pleasure or game for the children. Children do not know any boundary, any restriction. Why? Because it is the age for him to live for themselves. And we also say, or we can say, that the children are the national asset or the supreme asset of any country. So these are the some perceptions regarding the introduction of my topic. When we discuss regarding the protection of rights of child, the first question come in our mind, that who is child, है ना? And up to what extent of years we can consider a person a child, or after that we can consider that he is not a child. So this concept has been in debate from a very long time. And when you go through the different legislations in our country, you find that the different ages are fixed. Means when we talk about the criminal liability of a children, we find that a person up to the age of 7 years is totally immune, totally exempted from any kind of criminal liability, है ना? And person between the years of 7 to 12 years is uh, under criminal liability if he is knowing the consequences of the activity which he has been committed, or the offense he has been committed, है ना? When we go through the labor laws, we find that a person below the age of 14 years cannot be engaged in any hazardous or dangerous activity or factory or engagement, you know. So the different perceptions has been taken with respect to the different concepts or different legal concepts. So first I would like to draw your attention with respect to the age of the children uh, in Indian mythology. Indian mythology divides the children in five categories, in five stages actually, है ना? And these five stages are: number one, garb; number two, Chhidr; number three, Chhidr Anand; number four, Bala; and number five, Kumar. So basically, these are the stages of life of children. Garb, है ना? It means that when the person is having fetal period, है ना? He has not been begotten. He has not been seen the word from his eyes or her eyes. So that is called the garva position or the garva stages, है ना? That is up to his birth or her birth. The second stage accepted under the Indian culture, that is Chhidra. Chhidra means the age from birth to 6 months. है ना? The third stage is Chhidra Anand, means from 6 months to 2 years. The next stage or the fourth stage is Bal Avastha, we can say. So it is from 2 years to 5 years. And the last stage accepted in Indian mythology, that is Kumar Avastha, Kumar stage, and that is from 5 years to 16 years. Means up to the 16 years, the Indian mythology considered a person as a child, and the child has the different five stages. Why these five stages are accepted or recognized under the Indian culture or Indian religion? Because there are particular rituals, there are particular rites in the name of children, है ना? We all are very much acquainted with them, है ना? We were also children, and we have children in our family, and we found that the different rituals are there, है ना? Means whenever a person is begotten, his naming ceremony is there, नामकरण, हम लोग नामकरण बोलते हैं, है ना? After some time there is a अन्नप्राशन, है ना? So up to extent he is on liquid diet, and when he is introduced with the grains, with the fruit grains and the other foody items, that sanskar is known as annaprasan, है ना? We also have the mundan ceremony, that is tonsure ceremony, है ना? We have the upnayan rituals, है ना? Means initiation a child into religion and wider community, that is called upnayan sanskar. So the different kinds of sanskars or rituals are there. That is why in Indian mythology, the different stages of children are recognized. है ना? Even you would have seen, or you might have studied under the criminal law system, if you have studied the history of Indian criminal legal system, that the children were never beaten up or punished by the hard either weapon or stick, है ना? They were always inflicted punishment with a bamboo, which is divided on the front, है ना? मीन्स एक बैम्बू लेते हैं, बांस को स्ट्रिप्स में डिवाइड्स कर देते हैं और उस बांस से हम उसको पनिश करते हैं, है ना? इट मीन्स दैट इट इज अ वेरी low level of punishment for the children. It is accepted that they cannot be inflicted a heavy punishment or very tortured punishment or very corporal punishment. We punish him with a very exemplary punishment, so that they should not get any kind of physical injury or mental injury. So that is why the stages are there for different kind of treatment. When we go through the international debates regarding the age of child, we found that there also the different concept has been taken into consideration, है ना? I would like to give the example of Minage Convention 1973, which is also known as Convention number 138 of International Labour Organization, है ना? We all know that International Labour Organization has adopted so many conventions, in which one of the convention for minimum age convention, that up to what extent of age a person can be engaged in any entrepreneurship or factory or any employment. And this convention actually provides that a person more than the 15 years of age can be engaged, है ना? Even though there are several exceptions and restrictions of on this principle, that if the country's need are not satisfactory, or country is not financially and economically sufficient, in that case the age can be below the 15 years or 14 years also, है ना? So basically below the 15 years has been taken, but the 14 years age has been provided that if country is not sufficient, in that case it can reduce the age, but there must be a principle of 15 years. But this is not the universal principle accepted everywhere. When we go through the UNDRC, means United Nations Declaration of Rights of the Child, है ना? We will discuss its history and the history of other conventions later on, but now I am taking the concept of age which comes first, so that is why I am taking this initially. In the UNDRC, means United Nations Declaration on Rights of Child, there is no provision for considering the age of child. It is left totally on the member countries who have signed the UNDRC 1959. But the important document or manuscript adopted at international level is UNCRC. We all know that this is one of the most successful documents for the recognition of rights of children or protection of rights of children. It has been adopted in 1989, just 30 years after the adoption of UNDRC, है ना? Exact 30 year means the 30th anniversary of the UNDRC was the inception of UNCRC 1989. And under the UNCRC, Article 1 says that a child means every human being below the age of 18 years. है ना? Means a person below the age of 18 years is considered as a child under the UNCRC. With one proviso is there, that if the age of majority is different in the member country, in that case the age of majority would be applicable as the legislation says. So if age of majority is 16 years in any country, in that case that would be applicable, that would prevail. But no age of majority has been fixed, and he is the member country of the UNCRC. In that case, the age of majority is 18 years, means below the 18 years a person is a child. So this is basically the concept of who is child, है ना? Means there is no unanimously decision over the age of child, because before these documents, means UNDRC, UNCRC, different ages were there. है ना. And due to those different ages, we never came on a conclusion that this would be the age of majority, or below that age the person would be children. So the different things has been taken into consideration with respect to the view of different countries, है ना. Now the question comes that from where the regime of development of rights of children has been started, means from which year the recognition of rights of children was started. So it has a long history, है ना. It has a history earlier than the first world war. uh, there were the recognition of some rights, means there were some rights recognized in the name of right to employment by the ILO. So there were ILO conventions which provided that the person below this particular age cannot be engaged in any employment or entrepreneur. But when the First World War was uh, happened, then the more victims were children. Means children were the largely victim of.
Exactly.
Hello, hello, am I audible?
Sir, at times you were not, but now you are audible.
Okay, okay. So, just after the First World War, we have seen that the children were largely victim of the violence and inhuman treatment. है ना? We all know that the First World War was started by the few countries, है ना? But the victims were those persons who never took into the part of those violence or inhuman treatment. So, when the First World War was over, then it was considered very sharply that what what can be done for the protection of the children, you know. Immediately the League of Nations was established, you know, for establishing the peace and security in the world. And League of Nations, taking the considerations of so many persons or international organizations, established a committee which was known as the Child Welfare Committee. This committee was established in 1999, but we all know that League of Nations could not be succeeded, and it could not be reached to its fate for which it was established. So neither the League of Nations nor the Child Welfare Committee, which was established in 1999, could done better for the care and protection of the children, है ना. But important development took place in the Britain. In Britain, there was a lady named Eglantine Jebb, and she, along with her sister, she founded a society, and that society is still known as Save the Child or Save the Children. You know, we all know this society. This society is working in most of the countries of this world very successfully, and this society is actually under the leadership of Lady Eglantine Jebb, along with her sister, is responsible for the recognition of rights of international level, or initiation of awareness for recognition of rights of children, है ना. What Eglantine Jebb did, Eglantine Jebb uh, took it up to means the society was carried on to international level. And the society developed a 5 point declaration, means in itself they developed 5 principles for the care and protection of the children, है ना, by the association of international union means international union of Save the Children, means Save the Children were working in different countries. They organized a meeting of the delegates of the different countries, which were individual, not the government officials, and they framed a document in which the 5 principles were accepted or adopted, है ना. And when these 5 principles were adopted, the Eglantine Jebb uh, started to aware the delegates of the different countries and the governments of different countries, as well as the international community, getting it. And they always raise their voice, है ना, internationally, and due to which the League of Nations took consideration of their voice. 1924, the League of Nations held a meeting in Geneva and adopted the League of Nations Declaration of Rights of Child. है ना, means the same declaration which was adopted by the Society Save the Children, the same declaration was adopted by the League of Nations in 1924. This declaration is known as the Geneva Declaration, है ना, and the Geneva Declaration has the same five principles which were adopted by the Eglantine Jug under the Society Save the Children, है ना. I in very precise manner recites those articles or principles. The very first one was the child must be given opportunity to develop materially and spiritually, है ना. This was the first principle. Second principle was taken into consideration because at that time, after the first world war, it was found that the number of children they died due to the hunger, they died due to the lack of medical facilities, they died due to the lack of livelihood. So the second principle was based on that the child uh, that is hungry must be fed, you know, that is sick must be nursed, that is backward must be helped, and that is delinquent must be reclaimed, and that is orphan must be sheltered, है ना. Because in second world war the so many children were abandoned, found orphan, without having any family. So these provisions were provided for protection of that. The third principle was that it is the child who must get the relief first if there is a time of distress. Means if there is any calamity, if there is any war, if there is any pandemic disease, in that case the first relief must be given to the child. This was the third principle. The fourth principle was that child must be put in a position to earn livelihood. If a child is sufficient enough to earn the livelihood, he must give an opportunity. And the last one was that the child must be brought up in consciousness, है ना, that in talents must be devoted to the service of fellow man. So these were the five principles which were taken in order to protect the children. And the important thing of this Geneva Declaration was that the first time it was considered that the children are not the responsibility of the family alone. The children are responsibility of the family, of the community, of the nation, and
Sir, your voice is
inter-
not coming.
my voice is not clear. It is not clear.
Sir, now it is clear, but it wasn't clear 2 minutes ago.
Oh, why it is happening? My network is showing the signals properly, and I am working on broadband. So I am very surprised that I am not audible properly. Okay, so the five principles were adopted under the League of Nations supervision by the Declaration of Geneva, and the important development which took place that the children became the responsibility of not only the family but the society, nation, and international community. Means all should work for the welfare of the child combined in combined manner. Okay. Uh, the League of Nations could not prevent the Second World War, another World War, and the entire planet engulfed in the Second World War, which caused greater sufferings. है ना? And again, the children were largely victim. So that is why after the getting it, you all know that in 1948, the General Assembly of the United Nations adopted the Universal Declaration of the Human Rights. है ना? So this was the major document for the protection of the human rights of all. In this document, the number of human rights were adopted. But unfortunate part of this document was that there were very few articles for the protection of children. Means the children were not specifically protected under this United Nations Declaration of Human Rights. है ना? There were articles, but articles were not comprehensive enough to cater the needs of the children. Like there was Article 25, and subclause of this Article 25 too says that motherhood and childhood are entitled to special care and assistance. है ना? The subclause of this subclause 2 says that all children, whether born in or out of wedlock, shall enjoy the same protection or same social protection. है ना? The Article 26 of the UDHR says that everyone has the right to education, and education shall be free at least in the elementary and fundamental stages. The article again says elementary education shall be compulsory. So we can understand that the concept which we adopted in 2009, है ना, by the Right to Education Act 2009, और फ्री ने 2009 में एक्सेप्ट किया, and internationally it was accepted in 1948. In the developed countries it was adopted or accepted a long back. यूरोपियन कंट्रीज में, लैटिन अमेरिकन कंट्रीज में, ऑस्ट्रेलियन कंटिनेंट में, है ना, चिल्ड्रन इन आवर कंट्री, that we have taken at least a half decade to understand that what is the need of the children in the name of education. Okay, uh, these are the protections which are it. So it was found that it is not a comprehensive document to protect the children. That is why United Nations, on the demands of several countries, adopted a declaration in 1959 that is known as the United Nations Declaration of Rights of Child. As the Geneva Declaration was adopted by the League of Nations, in the same manner, the Declaration on Right of Childs was adopted by the United Nations in 1959. But the race, color, sex, language, even another thing were also added, that religion and political or other opinion. One thing. And second thing, either of himself or his family. Means if a family is having a faith in a particular ideology, in a particular religion, in that case the child cannot be discriminated on the basis of ideology of the family. The child cannot be discriminated on the basis of ideology and perception of himself or herself also. So the religion, opinion, national or social origin, these things were also included under the UNDRC 1959. So the first principle was right to equality, means to provide right to equality. The second principle was to provide right to all-round development, means there are certain kind of development with respect to the child. Child does not need only the physical development or mental development. He also needs the moral development, the spiritual development, the social development in a healthy manner, in a normal manner, in a healthy. So that is why these kinds were adopted in the name of all-round development. The third principle was right to identity. Means whenever a child is begotten, he must be given a name. He must be given a nationality in the country he has begotten. So he has the right to identity. Fourth principle was right to social security and health. He must grow in a healthy manner. In the social security, this must be provided to the children. And it must be provided to the prenatal and the postnatal. The social securities, we know that the nature bless some children, but the nature does not bless some children. Means that some children, their needs are different. If a person is physically challenged, then he needs a different mode of transportation. He cannot ride bicycle. If a person is ophthalmologically disabled, then he or she needs special assistance. He and she needs the books or the writing materials in the braille language. He or she cannot read. So that is why the special needs are there. That is why right to special treatment has been accepted there. The sixth principle was right to be cared, means he must be cared by the parents, by the society, as well as the country, up to the age of childhood. The seventh principle was right to free and compulsory education. Means up to the elementary stages, there must be free and compulsory education. Another one was right to receive reliefs in the case of distress, in the case of pain, in the case of uh, abnormal activities. He must get the relief first. Principle 9 was right against cruelty and exploitation. Huh? Uh, it, it is the evidence that the children were subject of cruelty and exploitation all around the world. So that is why this right was taken into consideration against children. And the last principle was right to protection against illegal practices. It was found that all over the world there are illegal practices in the name of child. है ना? Somewhere there are engravings on the children, somewhere there are practices which are brutal in the name of children. है ना? So these illegal practices were prohibited. So these are the 10 principles which were taken into consideration. But actually, it was a declaration, so it could not be implemented, है ना, legally. है ना? There is no binding force behind this declaration. So that is why these were mere obligations, mere objectives, pious goals. But the countries were never under compulsion to recognize these pious obligations due to the adoption of the declaration, not the convention. So up to a long time, these principles were not adhered by the different member countries in their legislative system, in their domestic legal system. So it was found that up to a large extent, the recognition of rights of children were never taken into consideration by the different countries. है ना? But it does not mean that it does not have any effect on the countries. है ना? If we take the example of Indian legal system, we find that there were several developments taken place under the influence of the UNDRC. है ना? I take these examples in a very precise manner. The third 5-year plan from 1961 to 66, है ना? It provided that there must be intersectoral coordination for the service of children. Immediately just after the adoption of this declaration, the third 5-year plan, when it came into implementation, the priorities were changed with respect to the children. You know, you would be surprised to know that in 1964, the government of India established a department that is known as the Department of Social Security, you know, for the protection of children and women. It was renamed as the Department of Social Welfare in 1966, and this department was elevated as Ministry of Social Welfare, है ना, later on. And it was again renamed as Ministry of Social Justice and Empowerment. So this is the department which is taking the consideration of the rights of children. In 1965, Food and Nutrition Board was started. Was the Child Labor Act 1986. So these are the legislative developments which taken place under the influence of the UNDRC, though UNDRC was not compulsorily binding on the Indian legal system, because it was mere a declaration. Uh, Due to its status of declaration, some problems were frameworks of rights of children. Neither the rights of children were comprehensively recognized in any of the documents. है ना? Later on, the ICCPR 1966 and ICESCR 1966, है ना, which are known as International Covenant for Civil and Political Rights and International Covenant for Civil, Economic, Social, and Cultural Rights. These covenants were adopted, but these covenants were also are on the footings of the UDHR. That is why the children were never given very. So finally, in 1989, on the 30th anniversary of the UNDRC, means 30th anniversary of the UNDRC, on the same date, it was adopted by the United Nations. And this is one of the most successful convention of the United Nations. It is one of the most important conventions of the United Nations, because first time the different provisions were provided under these conventions. You know, before going into the articles of this convention, I would like to draw your attentions uh, with respect to special features or salient features of this convention. You know, the salient feature of this convention are that this convention has been uh, divided into three parts. है ना? And the first part talks about the recognition of rights of child. है ना? Means Article 1 to 41 provides the recognition of different rights. Means whatever rights those may be considered at the time of adoption of this convention were given place under this convention. है ना? Article 1 to 41, this is the major part of the convention. Rest of the parts are very precise, not as comprehensive as the part 1. So the part 1 is written very comprehensively describing and providing the recognition to each and every right of the children. The second part talks about the Committee on Rights of Child. है ना? It was found by the United Nations by the experience of different earlier conventions that the conventions are there, but there is no evaluation or examination of the working of different countries with respect to the certain rights, like ICCPR, SCR. So in this convention, it was provided that not only there would be the recognition of the rights, but there must be a mechanism to evaluate, to examine the status of developments of rights of different countries. That is why a committee was established that is known as Committee on Rights of Child. So this is another important feature of this convention, which is hardly found in any other convention. And the part third, which starts from articles 46 to 54, have the miscellaneous provisions. You know, there can't be working of any convention unless we are having the different miscellaneous provisions. Means what would be the institution, how the institution will run, where will be the office of the institutions, what would be the office bearers, what would be their powers. You know? So these provisions are given from article 46 to 54 under part third. So this is the these are the salient features in the name of skeleton of the convention. We can see the other aspect of the convention. Means what are the special features of the convention? The special features are that there are adopted 3 P's, 3 P, है ना? As we say na, 3D, devotion, dedication, है ना, and determination. So here 3 P's are taken into consideration. These 3 P's are the salient feature of this convention. The very first P is provision. है ना? Provision means distribution of resources. Means under this convention, the different resources has been provided to the children. है ना? Resources means protection to health, protection to education, protection to mental well-being, protection to social security, and different other things are there. Means they are the recipients of so many resources, so many care, so many protections. So this is the first P, which provides provisions. Means different provisions has been provided for different kinds of distributions. The second P is protection. Protection means not only the rights are recognized, but they are given the protection by way of the legislative measures, by way of the executive measures, by way of the judicial measures. So protection stands for the right to be shielded from certain acts and practices. Means the whole parenting has been given. So this is the second P. And the third P talks about the participation. Before the adoption of this convention, it was the principle that it is the major persons who are authorities to say that what is good for the children and what is bad for the children. है ना? Means the other persons are considering the benefits of the children. Children were never given opportunity or were given opportunity to took part into the debate for the well-being of their rights, that which things are needed or which things are not needed. So the third P means participation, that the participation of the children was ensured in the matters or affairs of the children. है ना? Means the different platforms has been given to the children in order to raise their voices for their betterment, for their needs, for their demands, for their claims. So this is the participation. So it means that protection, है ना? Provision, protection, and participation. These are the three P's which can be understood as a silent feature. है ना? There are some other things which has been part of the this convention. Means at the time of drafting of this convention there were several debates. This convention was not very much easy to adopt, है ना? It is a very hard work which has been done by the member countries in order to reach a single conclusion. This document is a single conclusion, है ना? I would like to draw your attention with respect to certain issues which were behind the member countries in the name of conflict. For example, the third world countries were having the different practices, religious practices, cultural practices, है ना? Regional practices, है ना? Like in African countries there were practices to have a tattoo on the body of the child. They were having the practices to pierce the ear, the nose, the cheeks, the body of the children. So the Western country was considering it as a atrocity, cruelty, है ना? Or torture to the children. But the Arab countries, the African countries, the Asian countries, and the Eastern countries, they were saying that it is our religious right, it is our cultural rights, it is our regional rights. So we cannot withdraw it, we cannot dilute it. But the Western countries, they were saying no, it is the torture against him. So this was a conflict between the countries, and how it could be resolved, no one was to take his step behind, है ना? So then it was reached that the practices which are torture, है ना? Torture means which provide the physical atrocities, है ना? They must not be performed in the name of child. Very by very extensive steps, member countries were agreed to this extent. Another, the important debate was on the right to life. This was one of the most important debate between the countries at the time of drafting of this convention, है ना? Means when it was the demand of protection, the member countries which were belonging to the African, Arab, Asian, and other countries, they were demanding that there must be protection of life before the birth and after the birth also, है ना? But the Western countries were saying that we can accept the protection after the birth, but we cannot accept the protection before the birth. Why? Because if we will accept the protection before the birth, in that case the women will never get the right to abortion. If we will consider the child who is in womb, who is in fetus, as a child, as a person, in that case the mother would not have right to abortion. And right to abortion was the right recognized in the Western countries very largely. Even there are leading cases, है ना? On the contraceptive pills, on the mechanism to abortion, है ना? So there was a conflict, that from which extent the right to life must be ensured to the children, either before the birth or the after the birth, है ना? So it was also resolved by the very long and large discussions and it was resolved that after the birth the protection can be given, because most of the countries were the common law countries, and in the common law countries, under the jurisprudential aspect, the person before the birth is not a person. है ना? Means a person who is in womb is not a person unless and until he has been begotten. If we go through the Indian Penal Code, we find that mm, injury to a fetus is a injury to the woman. है ना? It is not injury to the child. So there are different concepts in the civil system and the criminal system. An offense is when the child is begotten. Before the child is not begotten, there can't be offense against the child. है ना? There are section I think 310 or 312 under the Indian penal code. So the same were the concept in most of the common law countries. That is why it was the debate. So largely it was said that person who is in fetus do not have right to life. The person has right to life when he has been begotten. ठीक है? So this though the right to life has been accepted under the article 6, है ना? So it is written in article 6 that the person has right to protection before the birth and after the birth, but it does not mean that he has the right to life before the birth, है ना? It has been resolved by the drawbacks preparatoires, है ना? When these confusions came, then a document was prepared and the name of that document was drawbacks preparatoires. This is a Latin term, and this document says that what is the clarification over the terms which has been used under the declaration, under the convention. Then in convention the term is used that right to life is before the birth, life is available only after the birth of the child. So these are the concept with respect to the right to life of the children at the time of drafting of this convention, है ना? This convention is having article 1 to 41 in the name of recognition of rights, है ना? I would like to express some of the articles which are important in this lecture. We cannot discuss all the rights, है ना? So the article 1 is very important, which provides that a person below the age of 18 years is a child, unless means a proviso is there, unless under the law applicable to the child majority is attained earlier, है ना? So if in any country the age of majority is earlier than the 18 years, means 16 years, 15 years, 17 years, है ना? In that case that age would be applicable, and if there is no enactment, no law for that, in that case the age of 18 years would be applicable with respect to the purposes of this present convention. So means this convention is flexible in nature. It set a standard of 18 years, but that 18 years standard is not very much rigid, but it is flexible up to the enactment of the country. Article 2 provides right to non-discrimination, means the person cannot be discrimination on the same footings as we discussed earlier in the UNDRC, है ना? Article 6 which we took in consideration is here that state parties recognize that every child has the inherent right to life. Here it is written that every child. So every child means a child which has been begotten, means not before the birth but after the birth. So the protection has been given before the birth, after the birth, but right to life has been given only after the birth. So it can be cared, it can be nurtured, है ना? Article 7 make it clear that the child shall be registered immediately after the birth and shall have the right from birth to name, है ना, to nationality and to know, है ना, and to be cared by his or her parents. Yeah. So means a person who has been begotten, means after birth he has right to get a name, get a nationality, and get to know and cared by the parents. And their parents cannot be taken away from the children. So this is Article 7 with respect to the protection of the children. And I would like to express Article 13, which provides the right to freedom of expression. है ना? Means the person has the right to seek, to receive, to impart information and ideas of all kinds regarding all frontiers or regardless of any frontier. है ना? The same kind of thing has been accepted in ICCPR and the UDHR. On the same footing, the things has been accepted here. We must also take one of the salient feature of this convention, that this is not the convention which is away from the earlier conventions. No, in the preamble of the convention, this convention, the UDHR, the United Nations Charter, the ICCPR, the ICSCR, the UNDRC has been either reaffirmed or recited, है ना, in the same manner. Means this uh, convention is a further step of the earlier conventions. It is not away from the earlier conventions, but it is on the footings of the earlier conventions or covenants or the declarations. That is why the sum of the provisions of the earlier conventions and declarations has been given place in the different articles of this convention. There is Article 17. I told you that right to participation has been provided to the children, and this article says that state parties recognize the important functions performed by the mass media and shall ensure that child has access to information and material from a diversity of the national and international resources. When the child will have the platform to express its views and to receive the views of the whole world, the rest of the world, in that case they can participate. So that is why the media platform must be provided to them in the name of magazine, in the name of newspaper, in the name of pamphlets, in the name of banner, in the name of other devices. So this Article 17 is a very special article which provides the right to participation, which was never given to the child by any of the document. So this is one of the most important article of this convention. There are some articles of this conventions which are there. I am not going into that. I would like to discuss the Committee on the Rights of Child, which has been given from 42 to 45 article. And in these 4 articles, it has been provided that there would be a committee at international level, which would be known as the Committee on the Rights of Child. There would be 10 members from the different fields, which would be elected by the General Assembly, and these member countries will examine the development of rights of child in every country. Means they would be assigned the jurisdiction of few countries, and the member of Committee on Rights of Child would examine and prepare a report within every 2 years, means after every 2 years, and he will submit its reports to the General Assembly. And under the General Assembly, it would be considered that what are the development which has been taken place under that country. And when the meeting would be considered, then it would be asked from the delegates of that particular country that why all the principles has not been accepted in the member country. You all know that whenever there is a convention or meeting of any convention, the delegates are answerable in that country. The delegates justify that what developments they have been taken with respect to this certain principle. So that is why the countries are developing themselves. Under the influence of this convention, there are a lot of developments has been taken place under the Indian legal system after the 1989. After the 1989, there was the recognition of rights of children in the 21st century, especially. Earlier were also there, but not in the manner which has been taken place in the 21st century. In the 21st century, there were Free and Compulsory Education Act, Food and Security Education Act. The different colleges and institutes were established. The several legislations are there for them. The aims, different aims has been started in the different capitals of the country or different cities of the country, and enactments were there in the first decade of the 21st century. The POXO was taken into consideration. In 2000, the Juvenile Justice Act was enacted, which has been repealed in 2015, and new Juvenile Justice Act 2015 was taken into consideration. In 2016, the Child Labor Amendment Act was taken into consideration, and you also know that different kinds of policies and programs were also taken into consideration in 2013, in 2016. है ना? And under the pursuance of those articles, those policies, those legislations, है ना, the Indian judiciary has also pronounced the judgments, the different judgments for the betterment or for the recognition of rights of the children. So this is all about the international perspective of protection of human rights of the children. There are different aspects of the human rights of the children. I took only the international perspective, and if would be given opportunity, I'm ready to take the other aspects of the human rights. है ना? So with these words, I rest my case here, and I am again expressing my deep sense of gratitude to the organizers, coordinator of this refresher course. Thank you very much for giving me opportunity.
Thank you, Adesh ji.
Okay, sir.
Now, Nutan, Dr. Nutan.
Yes, sir. Pranam, sir. Sir, I have a question. Yes, just
Yeah.
now you
The floor is open for questions.
Sir, I just want to know that give some details regarding the provisions for children, especially Juvenile Act in Indian context, sir.
In Indian context,
Yes, sir.
ma'am, there are several provisions under the UNCRC for the juveniles, and under the influence of those provisions, the Juvenile Act has been not only framed and re-elected again, है ना? Means the Beijing rules were there in 1985, है ना? And under the Beijing rules, there were provisions largely which has been accepted at international level, and on the footing of those Beijing rules, we have enacted the Juvenile Justice Act 1986, है ना? But later on, there was the Rihad guidelines, and there were Doha guidelines in which the juvenile justice was again reclaimed. Yeah? And that is why we repealed the Juvenile Justice Act 1986, and we enacted a new law, Juvenile Justice Act 2000. But under the influence of several revolutions which took taken place in the Indian culture, the Juvenile Justice Act was again enacted in 2015. है ना? And the main thing is that the Juvenile Justice Act 2015 is breaching the several provisions of the UNCRC as well as the Beijing rules. But under the some voices which were raised by the different political parties, we gave some unfortunate part to the Juvenile Justice Act 2015.
Thanks, sir.
Okay.
योगेंद्र जी,
Hello. Doctor sir. Please introduce himself, sir, and say about your feelings after class.
सर पहले तो आदेश जी को बहुत बहुत आभार कि उन्होंने डिफरेंट एस्पेक्ट्स को हम लोगों के बीच में रखा।
थैंक यू सर।
मैं बस यही कहूँगा, थैंक यू।
Thank you, Adesh ji. Thank you so much for
Okay,
your
sir. Thank
such
you.
a
And
valuable-
it was a very nice experience to interact with the different august members of different departments of law. And I feel very humble, and means I cannot share my views here. And I will give my feedback to the Yogendra sir. And I feel very happy to interact with you. It is a nice experience.
इसीलिए अभी हम बोल रहे थे कि सर प्लीज से अबाउट योर इंट्रोडक्शन। पटेल सर
इंट्रोडक्शन दे देते हैं।
सर
मैं अजय पांडे हूँ, आर्ट्स कॉलेज, मेरा विषय स्कल्पचर है, इसलिए भी और रुचि रही मुझे आपके इस विषय को सुनने में।
ओके ओके, थैंक यू सर।
other participants, Ramaशंकर जी।
प्रणाम सर, मेरा नाम डॉक्टर रमाशंकर है सर।
नमस्कार
मैं
रमाशंकर जी। जी
जी सर, मैं सीएम लॉ कॉलेज दरभंगा से हूँ मैं सर।
जी जी जी।
रुचि सिंह।
पटना सर का शिष्य भी हूँ। पटना लॉ कॉलेज से ही मेरा सारा जो लॉ का डिग्री है, पीएचडी है, सब पटना लॉ ही कॉलेज से।
जी जी, एलुमनाई हैं आप पटना कॉलेज के।
जी सर।
मैडम रुचि सिंह।
Good afternoon, sir.
गुड
I'm
आफ्टरनून
Ruchi, sir,
यस मैम।
assistant professor here only in Patna Law College, Patna University only.
ओके ओके
It was great hearing you, sir.
ओके, सेम हियर मैम, सेम हियर।
डॉक्टर नूतन।
मैम यू आर नॉट ऑडिबल, यू आर ऑन म्यूट।
अनम्यूट करिए।
Sorry, sir. Ma'am, sir, I'm Dr. Nitin Kumari, an assistant professor, Department of Political Science, TPS College, Patliputra University. Sir, today's topic was very nice because we are mothers, so it is really would be good that we should know that there is right of participation for children also.
डेफिनेटली मैम।
Thanks, sir.
One thing I would like to say that a lot of work has been done at international level for the protection of rights of child, but due to the non-sensitive attitude of the legislators, bureaucrats, and the society as well, we are not implementing the whole thing. Means we cannot expect these things in the foreign countries. With your wishes, I got an opportunity to be in the New York, America for 7 days to attend a conference, and thereby I have found that whatever they said in the name of protection of human rights, they have did that. Means they are not only speaking about the human rights, but they are implementing their human rights in their mechanism. That is the most important part. Means you would not see any kind of child labor in either restaurant or any other of entrepreneurship in the America. Even if a parent is beating the child, in that case there are helpline numbers which are aware to the children in the schools, in the parks, in the other things, and the children are knowing that if somebody will show me a hand to beat me, then immediately he will say that 911, call to 911, means मैं 911 पे कॉल करूंगा और मम्मी पापा जेल करा दूंगा आपको। तो दिस इज द सेंसिटिविटी, है ना। सोसाइटी में जब तक सेंसिटिविटी नहीं होगी, हमारे यहाँ क्या है कि हम अपने आसपास देखते हैं कि बच्चा काम कर रहा है, बट वी नेवर टेक कंसिडरेशन, और कंसिडरेशन करके हम कर भी क्या लेंगे, है ना। हम पुलिस के पास जाएंगे तो पुलिस उसको भेज देगा एनजीओ में, और एनजीओ में भेज के उसके साथ क्या क्या नहीं होगा, मतलब हम अंदाजा नहीं लगा सकते। तो जो हमारे यहाँ मैकेनिज्म है वो अपने आप में इतनी अनसेटिस्फैक्ट्री मैकेनिज्म में काम कर रही है कि हम किसी को भेज रहे हैं एनजीओ में लेकिन ऑर्फान हाउस में तो उससे भी दुर्गति है उसकी। कम से कम वो खा कमा तो रहा है किसी दुकान पे, है ना। एनजीओ में जाएगा तो उसका बलात्कार होगा, उसका फिजिकल और मेंटल हरेसमेंट होगा, हम अंदाजा नहीं लगा सकते। हमने सुना है कई जगह, अक्सर हम लोग पढ़ते रहते हैं न्यूज में। तो टोटल इनसेंसिटिव सोसाइटी हो गई है, चाहे वो सोसाइटी हो, चाहे वो ब्यूरोक्रेट्स हो, चाहे वो लेजिस्लेटर्स हो। ये अनफॉर्चुनेट पार्ट है हमारी कंट्री का।
Sir, but headline numbers won't hamper the culture of Indian society. Otherwise, they won't reveal urbanity. They would simply become indisciplined, sir.
Of course, ma'am, of course.
सर बहुत बहुत धन्यवाद सर। मैं सुधांशु शेखर, दर्शन शास्त्र विभाग टीपी कॉलेज मधेपुरा में हूँ।
जी जी।
और सर बहुत अच्छा लगा कि हम लोगों ने बच्चों के बारे में सोचा। हमको लगता है बच्चे सबसे उपेक्षित हैं, दलितों एवं महिलाओं से भी ज्यादा उपेक्षित हैं, क्योंकि बच्चे के पास तो कुछ होता ही नहीं है जो अपनी आवाज वो उठा सकें। जो अमेरिका की आप बात कर रहे हैं सर, जब बोलने के लिए आएगा तब न वो कॉल करेगा और कहेगा। उससे भी बच्चे, यहाँ तो बच्चों को भ्रूण हत्या कर दी जा रही है, उनको जन्म ही नहीं लेने दिया जा रहा है। तो हमको बच्चों के अधिकार की बात सर वहां से करनी होगी। और बहुत अच्छा लगा कि आपने बच्चों को केंद्र में रख करके अपनी बात रखी है। और मेरा यह मानना है कि हमें इन चीजों को राजनीतिक विमर्श का और सामाजिक विमर्श का भी केंद्र बनाना चाहिए, क्योंकि मान लीजिए अगर दलित हैं, महिलाएं हैं, तो वो भी कुछ ना कुछ सक्षम है। अगर बूढ़े हैं तो उन्होंने भी अपने जीवन के 60 वर्षों में कुछ ना कुछ अर्जित किया है, जो उसके लिए संरक्षण का काम करते हैं। लेकिन बच्चों को अगर हम अपनी तरफ से नहीं देखें तो उनके पास अर्जित कुछ भी नहीं है। इसलिए बाल अधिकार के संरक्षण के लिए अधिक से अधिक काम करने की जरूरत है। और बहुत अच्छा लगा कि हमारे कोऑर्डिनेटर साहब ने आपको आमंत्रित करके हम लोगों को इस पक्ष के प्रति भी जागरूक किया है। कोऑर्डिनेटर साहब को भी हम लोग आभार व्यक्त करते हैं उनके प्रति।
जी जी जी, कोऑर्डिनेटर साहब को तो बहुत विशेष आभार है कि उन्होंने डिफरेंट डिसिप्लिन के लोगों के साथ इंटरेक्ट करने का मौका दिया, है ना। मैं तो पहले समझता था कि लॉ का होगा, लेकिन बाद में मुझे पता लगा कि यहाँ डिफरेंट लीगल लिमिनरीज ही नहीं आए हुए हैं, बल्कि डिफरेंट डिसिप्लिन से भी लीगल अदर लिमिनरीज आए हुए हैं, है ना। तो आई एम सो मच एक्साइटिंग टू हैव माय डेलिब्रेशंस विद यू।
डॉक्टर वंदना,
अच्छा लगा सर। अगर आपका वीडियो भी हम लोग को दिखाई पड़ता और पावर पॉइंट भी, तो और हम लोग अच्छे से उसमें
बस यही मुझे चीज खल रही है एक्चुअली, है कि मुझे लगता है ना कि मेरा कैमरा जो है वो सिस्को वेबएक्स के साथ इंगेज हो गया है, क्योंकि हम लोग बीएचयू में उसी से क्लास लेते हैं। मैंने उसको अनइंस्टॉल करने की कोशिश की।
बहुत अच्छा लगा सर, हम लोग को बहुत धन्यवाद सर।
जी जी,
नमस्कार सभी को। नमस्कार सर,
नमस्कार।
मैं डॉक्टर वंदना सर, बीआरएम महिला कॉलेज
जी
मुंगेर
जी
यूनिवर्सिटी से हूँ। मेरा सब्जेक्ट
जी।
दर्शन शास्त्र है सर।
जी
और मेरे 2 बच्चे हैं सर। आज लॉ के बारे में, बच्चों के इतने सारे लॉ के बारे में जानकर बहुत खुशी हुई सर, बहुत ज्ञानवर्धन हुआ। थैंक यू सर आपका।
चलिए,
बच्चों का गाना भी सुनाई दे रहा है।
हाँ सर, वो बोल भी रहा है सर।
very much thanks all of you, but don't leave the link. At 3 p.m. Professor Manik Chakravarti sir will join us. So other member who don't will not joining us, please say to join. Dr. Adesh, thank you so much on behalf of the participants and on behalf of Postgraduate Department of Law, Patna University.
आदेश सर ने खुद अनम्यूट कर दिया है।
हाँ सर, थैंक यू सो मच फॉर गिविंग मी दिस अपॉर्चुनिटी, एंड इन फ्यूचर also whenever you will call me, I would be available always, because it is my moral duty to be there for any activity.
नहीं, बिल्कुल सर, हम लोग लेते रहेंगे बराबर आपका जो है
जी
सपोर्ट और हेल्प जो है।
ओके, सो मे आई लीव सर?
ओके सर,
ओके, थैंक यू
थैंक्स सर, थैंक्स।
थैंक यू सर।
वेलकम थैंक यू
यही है बैठ करके आगे मान सर। प्रणाम सर।
प्रणाम सर।
सर नमस्कार।
नमस्कार सर।
सर अनम्यूट योरसेल्फ। आपका साउंड क्लोज है सर। सर प्लीज अनम्यूट योरसेल्फ सर। प्लीज अनम्यूट योरसेल्फ ऑडियो सर।
Yeah, right.
Sir.
Okay, good afternoon to all of you. Good afternoon.
Sir, good afternoon from my side also, sir. I am Virendra Gupta from Patna Law College.
Yeah, Virenji. No, yeah. I remember you. Thank you very much. Thank you. And
dear participants, today class and Professor Dr. Manik Chakravarti sir be with us, and he will deliver the lecture on title Right to Privacy and Human Rights, the Challenges in 21st Century. He is former Dean and Head Faculty of Law, University of Bardhaman, and former Director UGC HRDC, and sir, we also holding the Professor Emeritus, and after the lecture, I understand you will get more from sir. So please patiently hear the lecture and get the juice of jurist. Thank you, sir. Thank you so much, sir.
Thank you, Jogan.
Sir.
So, my dear participants, my dear friends, first of all, good afternoon to all of you and namaskar. And I'm very happy that today I have got this opportunity to speak on a very good, important topic, that is a right to privacy and human rights, the challenges in 21st century. First of all, I'm very grateful and thankful to the director, UGC HRDC Patna University, and also the head of the Department of Law. I'm very thankful to him, Dr. Y.K. Varma, who is very close to me. And also, I convey my heartfelt thanks to all the faculty members of Law, Department of Law, Patna University, and especially Bani and all the faculty members, and also all the dear participants, those who are attending this today's discussion on a very important topic, a right to privacy. So, first of all, please take it as a discussion because we are all teachers, and so I believe that we can have a very important discussion on a topic which is very burning, because this is burning due to some recent incident like Pegasus spyware incident, what you have seen in the newspaper, media, and also about heard, and also the Supreme Court initiative taken on this issue, Pegasus and spyware, and also due to the global surveillance disclosure in 2013 by one ex-National Security Agency employee of USA, Mr. Edward Snowden. You might have heard about the Snowden scandal, and also latest Cambridge Analytica data scandal. Due to all these things, this now right to privacy has got a lot of publicity and focus, both in international arena and also in our national arena. That's why I have chosen this topic for discussion today. And see, first of all, just I'm quoting some line from one writer, Clinton Rossetier, who wrote very nicely that privacy is a special kind of independence which can be understood as an attempt to secure autonomy in at least a few personal and spiritual concerns, if necessary, in defiance of all pressures of modern society. It is an attempt, that is to say, to do more than maintain a posture of self-respecting independence toward other men. It seeks to erect an unbreakable wall of dignity and reserve against the entire world. So this is very important to say here that right to privacy is very much a fundamental human right of all people in the world. See, first of all, I want to mention that if we see the Charter of the United Nations, you will find that in the preamble itself to the Charter of the United Nations, it is nicely mentioned. If you read the Charter, in the preamble of the Charter of the United Nations, you will find it is beautifully mentioned that we, the people of the United Nations, we want to determine to save the succeeding generations from the scars of war, what we have witnessed twice in our lifetime, and also to reaffirm our faith in, fundamental human rights, in the dignity and worth of human person. So, very interesting that in 1945, when the United Nations has been established, then we have got the Charter of the United Nations, because you know very well that on 26 June 1945, the Charter of the United Nations has been accepted, adopted nearly 50 by 51 countries of the world after the Second World War, which replaced the League of Nations. And the main objective or purpose of the United Nations is to protect the succeeding generations from the scars of war by way of maintaining peace, and also by way of maintaining equality on the basis of human dignity and individual freedom of all. So this is very interesting and important when we are talking about this, because the broad parameters laid down by the charter in respect of the human rights, were carried forward by the Universal Declaration of Human Rights, which was adopted by the General Assembly of the United Nations on 10th December 1948. Dear friends, on 10th December 1948, the General Assembly of the United Nations has adopted the most important document, which can be told as the Magna Carta of modern human rights, that is the Universal Declaration of Human Rights, which is consisting of all the civil, political, economic, social, and cultural rights of individual, where the dignity of individual, the equality of all men and women, of all people of the world, has been given in a very good way. Now, in the declaration, this Universal Declaration of Human Rights, as you know, the Article 1 of the Declaration nicely mentioned that all men and women are born equal in their dignity and rights. Now, interestingly, you see, when we are talking of right to privacy as a fundamental right, as a fundamental human rights, right to privacy of all man, because it is based on dignity of human being. I remember once Justice Krishna Iyer, the eminent Supreme Court judge, Justice V.R. Krishna Iyer, he nicely, mentioned in one judgment that the right to privacy is a very much fundamental right based on human dignity. That's why when we are talking of Universal Declaration of Human Rights, please remember that under Article 12 of the Universal Declaration, it is clearly mentioned that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, not to attacks upon his honor and reputation. Everyone has the right to protection of the law against such interference or attacks. So here, this is very important. You see, when I am talking of this Article 12 of the Universal Declaration of Human Rights, see, no one shall be subjected to arbitrary interference. Very important for the human dignity with his privacy, privacy of family, home, or correspondence, not to attacks upon his honor and reputation. Everyone has the right to protection of the law against such interference or attacks. So, the above provision generally included the privacy of family, home, correspondence, and personal privacy. And the nature of the right recognized in the declaration is to prohibit any kind of arbitrary interference, either by the state or by any agency, in the privacy of any person, and to extend the protection of law against such interference to everyone. Dear friends, you know that after this Universal Declaration of Human Rights, when it is adopted in the year 1948, then there were a lot of arguments by the jurists, on the point that this is a declaration. So these are not binding, because you know that under international law, any declaration that has no binding force. So ultimately, again, the it was, the United Nations has entrusted upon the United Nations Human Rights Commission to draft, the law on all the important civil, political, economic, social, and cultural rights, so that these documents should be binding to all. And accordingly, in 1966, we have got two important documents. One is ICCPR, International Covenant on Civil and Political Rights, and another one is International Covenant on Economic, Social, and Cultural Rights. And interestingly, so the UDHR has been further supplemented by these international covenants in 1966. And these three documents, thus taken together, comprise the International Human Rights Instrument, the core international human rights instrument, I must say. And the right to privacy, expressly recognized by the Universal Declaration, was further carried forward by the International Covenant on Civil and Political Rights. Because if we read the Article 17 of the ICCPR, International Covenant on Civil and Political Rights, then it is clearly mentioned in the ICCPR that no one shall be subject to arbitrary or unlawful interference with his privacy, family, house, or correspondence, not to unlawful attacks on his honor and reputation. So here also, under Article 17 of the ICCPR, we have seen that right to privacy has been clearly, protected. Now, in addition to these express provisions on right to privacy, there are also other human rights, contained in the Universal Declaration, which protect various aspects of privacy. For example, the importance of right to dignity, which is mentioned under Article 1 and Article 6. As I told you, that Article 1 of the UDHR proclaims that all men and women are born equal in their rights and dignity. Now, again, and the protection against torture, cruel, inhuman, and degrading treatment or punishment, and against arbitrary arrest, detention, or exile cannot be undermined. So these are all mentioned in the UDHR under different articles, like Article 5, Article 9 of the UDHR. My dear friends, here again I can mention another important document, international document, that is European Convention on Human Rights, which has been adopted by the European countries in 1950, European Convention on Human Rights. See, in respect of protection of privacy, this document is more elaborate, as it commands respect for private and family life, as well as home and correspondence of every person. It further prohibits any interference by public authority in the exercise of the above rights, and together with the recognition of the right to privacy, so it also provides for its limitations, which may be imposed in the interest of national security, public safety, or the economic well-being of the country. Now, here I must mention, so far our Indian context is concerned, as we know, that in 1949, when our constitution has been adopted by the Constituent Assembly, then we have found that, in the Indian constitution, in the preamble itself, it is clearly mentioned that, to secure justice to all men, to everybody, economic justice, social justice, political justice, which is also includes, here the, right to privacy, I must say. Though, of course, in the Indian constitution, of course, in the context of the Indian constitution, the above provisions are very significant, as because, our Indian government have ratified this ICCPR, India also is a party to this, and our parliament is obliged to enact laws for giving effect of international conventions. Now, here I must mention one thing, that in 1993, our parliament has passed the Protection of Human Rights Act. All of you are very much aware of this act, which is the Lone Human Rights Act in India, the Protection of Human Rights Act 1993. And if you see the definition of human rights mentioned here in this act, you will find that here it is clearly mentioned that human rights mean the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution are embodied in the international covenants and enforceable by the courts in India. Dear friends, very nicely it is mentioned in the definition of human rights. If you go to the definition given under the Protection of Human Rights Act 1993. So, in view of this unique provision in the statutory law, the enforcement agencies for human rights in the enforced law are obliged to take cognizance of the rights, recognized under international covenants. And it is significant to note here that the rights contained in the international human rights instruments are not enforceable as such by courts in India. But however, in the recent judicial trend, we have seen that, in the direction of enforcing international human rights as far as possible through directive principles and fundamental rights under the Constitution. The courts has mentioned many times the international instruments. In case of Bishaka versus State of Rajasthan 1997, we have seen that the Supreme Court has mentioned a very important international human rights instrument, CEDAW, that is UN Convention on the Elimination of all forms of discrimination against women, adopted by UN in 1979. Dear friends, so a positive obligation has been imposed upon the courts in India to give due regard to all international conventions and norms for constructing domestic laws. And in view of these developments, the right to privacy, as contained in the Universal Declaration and also ICCPR, may well be read and enforced as fundamental right in our Constitution. Now, when we are talking of our Constitution, I must admit the fact that there are no express words in the Constitution of India about the right to privacy, and it could not be found in any other statute, though interests similar to that were protected under Indian Penal Code, under Indian Evidence Act, and under the Constitution, although different names are given to it at different times. Now, see, when we are mentioning here Article 21, then of course in Article 21 it has been mentioned that the right to life and personal liberty of all man. So here it is very interesting here that the Supreme Court in various decisions has developed various rights, interest in all cases similar to privacy, right to free enjoyment, right to sleep, right to human dignity, right to have access to justice, right to human dignity like Bandhuva Mukti Morcha versus Union of India, then right to have access to justice, etc. And under the concept of personal liberty in Article 21. And the Supreme Court has held in one judgment that the right to life enshrined in the Article 21 cannot be restricted to mere animal existence. It means something much more than just physical survival. And the right to life includes the right to live with human dignity and all that goes along with it, namely the right bare necessaries of life, such as adequate nutrition, clothing, shelter over the head, and facilities for reading, writing, and also it includes a right to privacy, which is very dear to each and every human being. Now, dear friends, here I must mention one thing, that the Supreme Court for the first time considered the right to privacy in a case on police surveillance and domestic visit at night by the police personnel in Karaksing versus State of Uttar Pradesh. You can, I think, remember this judgment of 1973, Karaksing case, Karaksing versus State of Uttar Pradesh. You remember, I'm sure, in this case, Supreme Court had occasion to consider the validity of Regulation 236 of the Uttar Pradesh Police Regulation. It was held by majority judgment that Regulation 236B, providing for domiciliary visits, was unconstitutional for the reason that it abridged the fundamental right of a person under Article 21. And since Regulation 236B did not have the force of law, so the regulation was declared as unconstitutional. Now, the other provisions of the regulation were held to be constitutional. Now, the majority in this case said that personal liberty in Article 21 is comprehensive to include all varieties of rights which go to make up the personal liberty of a man other than those dealt with Article 19. So according to the court, while Article 19(1)(a)(1)(d) dealt with particular types of personal freedom, Article 21 take in and deals with the residue. So the court quoted, here that here right to privacy also is included under the right to life under Article 21. Now, here the court also referred to the preamble to the Constitution that it was designed to assure the dignity of the individual and therefore of those cherished human values as the means of ensuring his full development and evolution. Now, interestingly, after this case, what we have seen, in this case, of course, Justice Subbarao, who has given a dissenting opinion, he straightway, established the fact that the word liberty under Article 21 was comprehensive enough to include right to privacy also. He said that although it is true, our Constitution doesn't expressly declare a right to privacy as a fundamental right, but the right is an essential ingredient of personal liberty as mentioned under Article 21 of the Indian Constitution. In a subsequent case, Govind versus State of Madhya Pradesh of 1975 Supreme Court judgment, where Justice Matthew of the Supreme Court, taking the lead given by the minority judgment of Justice Subbarao in corruption case, and he ruled that Article 21 of the Indian Constitution embraces right to privacy and human dignity. So they learned this, in this case, of course, they examined the content of the right to privacy and observed that any right to privacy must encompass and protect personal intimacies of the home, the family, marriage, motherhood, and procreation and child rearing also. Now, in Maneka Gandhi case, if I mentioned Maneka Gandhi versus Union of India in 1978, in that case, of course, the expression personal liberty that has been explained by the honorable judges of the Supreme Court. And the Supreme Court in this case has widened the scope of the expression personal liberty and observed that the expression personal liberty in Article 21 is of widest amplitude and it covers a variety of rights which go to constitute the personal liberty of man, and some of them have been raised to the status of distinct fundamental rights and given additional protection under Article 19. Now, here I want to mention another important case when we have studied our personal law, our Hindu law. All of you can remember that very judgment, T. Sharita judgment, T. Sharita versus T. Venkaya Subbaiah. That very important judgment, we have read in reference to Section 9 of the Hindu Marriage Act. Can you remember, my dear friends?
Registration of marriage, sir.
Yeah, but that is very important in 1983 judgment, T. Sharita. Okay, wherein the court held that protection of privacy as a fundamental right in that case. And Justice Chaudhary of the Supreme Court, he extended the protection of privacy to inhuman and degrading treatment of forcible sexual cohabitation. And relying on this, the court extended this concept of sexual autonomy to a Hindu wife and struck down Section 9 of the Hindu Marriage Act 1955, which provided for restitution of conjugal rights. So very interesting. Though of course later on it was again held that no, this restitution of conjugal rights Section 9 doesn't violate the constitutional provision. Later on we have seen. So this is very interesting that many times the Supreme Court, while they're giving some judgments on even personal laws, they are taking, mentioning this right to privacy as a ground, of course. And T. Sharita case is one of that case where Supreme Court, took this right to privacy as the important personal right of every person. And so, they struck down Section 9 in this case, T. Sharita case, Section 9, the restriction of conjugal right as violation of Indian constitutional provision, right to privacy. Anyway, now, so what we have seen that, in case of situation, which is violation of individual dignity, and so that has been treated as a violation of right to privacy. and this is a fundamental human rights of all. And as you know that when we are talking of human rights, then please remember that these rights, are very fundamental rights, basic rights, without which a human being cannot survive in the society as a human being. So every human being, because these are inherent rights, and we need these rights for our overall development, which also the right to privacy. Now, of course, in another very interesting judgment is the state of Maharashtra versus Madhukar Narayan Mardikar 1991 judgment, where the apex court held that even a woman of easy virtue is entitled to privacy, and no one can invade her privacy as and when he likes. So it is not open to any and every person to violate her person as and when he wishes. She is entitled to protect her person if there is an attempt to violate it against her wish. She is equally entitled to the protection of law, right to privacy under Article 21. Very important judgment, very interesting judgment. This judgment of State of Maharashtra versus Madhukar Narayan Mardikar. Okay, this is very important. And another judgment I can mention here of 1995, that is Radhagopal versus State of Tamil Nadu. That is also very important judgment, Radhagopal versus State of Tamil Nadu, where you see the Supreme Court held that the right to privacy is implicit in the right to life and liberty guaranteed to the citizens of this country by Article 21. And a citizen has a right to safeguard the privacy of his own, his family, marriage, and all. None can publish anything concerning the above matters without his consent and without whether truthful or otherwise. If someone does so, he would be liable in an action for damages. Now, in People's Union for Civil Liberties versus the Union of India, 1997, you see that very important judgment, because in this case it was held that a right to hold telephone conversation in the privacy of home or office without interference can certainly be claimed as a right to privacy. And conversations on the telephone are often of intimate and confidential character. So telephone conversation is a part of man's private life. In this judgment, People's Union for Civil Liberties versus the Union of India, that has been established by the Supreme Court. So telephone conversation is a part of man's private life, and right to privacy would certainly include telephone conversation in the privacy of one's home or office. So telephone tapping is a serious invasion of privacy and would thus infract Article 21 of the Constitution unless it is permitted under the procedure established by law. Ladies and gentlemen, here I must tell before you that now if we just take the other example, like Indian Telegraph Act 1885, Indian Telegraph Act, Section 5, subsection 2 of the Indian Telegraph Act 1885, it permits interpretation of messages in accordance with the provisions of the said section. Telegraph Act. Occurrence of any public emergency or in the interest of public safety are the sine qua non for the application of the provision of Section 5.2. Unless a public emergency has occurred or the interest of public safety demands, the authorities have no jurisdiction to exercise the powers under these provisions mentioned under Section 5, subsection 2 of the Indian Telegraph Act. Now, in this context, I must tell before you that just now I have mentioned the Supreme Court judgment, the People's Union for Civil Liberties versus Union of India. In this case, it was held that occurrence of public emergency or existence of any public safety interest, are sine qua non for application of provisions of Section 5.2. Now, another relevant case in this context, of course, R.M. Malkani versus State of Maharashtra, that is 1973, AIA 1973, Supreme Court judgment. And that was a case under Section 25 of the Telegraph Act, which states that if any person intending to intercept or to acquaint himself with the contents of any message, damages, removes, tampers with or touches any battery, machinery, telegraph line, post or other thing, whatever, being part or used in about any telegraph or in the working thereof, he shall be punished with imprisonment for term which may extend to 3 years with fine or with both. And in this case, R.M. Malkani versus State of Maharashtra, it was observed that where a person talking on the telephone allows another person to record it or hear it, it cannot be said that the other person who is allowed to do so is damaging, removing, tampering, touching machinery, line, etc., etc. So there was no element of coercion or compulsion in attaching the tape recorder of the telephone. So there was no violation of the Indian Telegraph Act. Now, we also can mention, see, some of the judgment from family laws. You see, as I told you that the privacy of family finds mentioned in some statutes. Say, for example, hearing in camera in certain marriage and divorce cases and statutes, may be said to have the aim of privacy in view. So it is said that confidentiality of proceedings is sometimes very much desirable, and that's why there are provisions of in camera arguments of the case, and this is much more so in regard to matrimonial proceedings. Often we see, and all the matrimonial statutes provide that at the desire of the parties, the proceedings may be heard in camera. And Section 22 of the Hindu Marriage Act 1955 provides for the same, because in Section 22 clearly mentioned that every proceeding under this act shall be conducted in camera, and it shall not be lawful for any person to print or publish any matter in relation to any such proceeding except a judgment of the High Court or the Supreme Court, printed or published with previous permission of the court. So this is also mentioned under Section 22 of the Hindu Marriage Act, as we have found. Similar provisions contained, of course, in Section 23 of the Special Marriage Act 1954, and in the Parsi Marriage and Divorce Act also 1936. Now, here I must mention that the similar provisions has been enacted also in the Indian Divorce Act 1869, though the provision is not as comprehensive as mentioned under Hindu Marriage Act 1955. Now, so for the Indian Evidence Act also, we find that there are provisions which protect the privacy interest of an accused person in view of the presumption of innocence under the law. And especially Section 24, we can mention here, confession caused by inducement, threat, or promise when irrelevant in criminal proceedings, mentioned. Section 25, Section 26, all this can be mentioned over here. And then, of course, if I take the example of criminal law, then also we find that there are some provisions which protect the privacy of individual. The reputation of a person is integral to one's personality and his privacy, and therefore it is generally protected through legal rules in a legal system. Any attack on it, an attempt to lower down the reputation, has been made a punishable offense under the criminal law, under Indian Penal Code, as you know, Section 499 of the Civil Penal Law, punishable offense under the criminal law. And Section 499 to 500 of the Indian Penal Code also deals with this offense of defamation. And whoever defames another is liable to be punished under the provision. So this is very important here, I must mention. And besides this, then again, we can mention another very important law, that is, the modesty of a woman has obtained special treatment in the Penal Code, and cases of any attempt to insult the modesty of a woman just by word, sound, gesture, or exhibition is also an offense, as mentioned under Section 509. So these are all very important provisions of different laws, statutory laws in India, which also directly or indirectly, protecting the private rights of an individual. Now, there are certain provisions also in CRPC, as we have found, which try to safeguard the privacy of the female. For example, Section 51, subsection 2 states that whenever it is necessary to cause a female to be searched, the search shall be made by another female with strict regard to decency. And so, again, Section 53, subsection 2 states that whenever the person of a female is to be examined under this section, the examination shall be made only by or under the supervision of a female registered medical practitioner. This special protection is afforded to females under the above provisions. Now, the provision relating to recording of confessions and statements in section 164 CRPC also makes a stipulation with a view to protect the privacy of a person. A statement of a witness or a confession made by any accused is not admissible in evidence unless the provisions of section 164 are strictly followed, as we have seen mentioned under 164. Similarly, if the provisions of section 165 not be valid, so the provisions of section 165 are mandatory for the conduct of enactment. You see, for example, I can mention here our information technology information secured from any electronic record book, register, correspondence, etc. from disclosure to any other person and makes it a punishable offense. If you read section 72 of the Information Technology Act 2000, there it is clearly mentioned that breach of confidentiality and privacy, save as otherwise provided in this act or any other law for the timing in force, if any person in pursuance of any of the powers conferred under this act, rules or regulations made thereunder, has secured access to any electronic record, book, register, correspondence, information, or other materials without the consent of the person concerned, disclosure, book, register, etc., shall be punished with imprisonment for term which may extend to 2 years and shall also liable to fine. Now, ladies and gentlemen, here I must mention one very important judgment of 2017, which all of you know it very well. That is the Justice Case Puttaswamy versus of India. A very remarkable, landmark judgment by the Supreme Court in the case Puttaswamy versus the Union of India, which has been delivered in the year 2017 on right to privacy. See, a retired High Court judge is freedoms carried by Part 3 of the Constitution, and it was also put forward to evaluate the correctness of the decision noted in Kharag Singh versus State of Uttar MP Sharma versus Satish Chandra on the ground that it violates the right to privacy under Article 21 of the Constitution. Now, so far the judgment is concerned here, the court has discussed various issues regarding privacy to facilitate the clear analysis. Privacy concerns against state and non-state actors. It was held that the claim of protection of privacy can be against both state and non-state actor, and as the danger in the age of technological development can originate not only from the state but also from the non-state entities as well. The second question was that is about the information privacy. It was held that informational privacy is an aspect of the right to privacy, and the right of an individual to exercise control over his data and to be able to control our existence on the internet, and unauthorized use of such information may therefore lead to violation of this right. Now, interestingly, so far the judgment is concerned in Puttaswamy case, a 9-judge bench of the Supreme Court of India passed a landmark judgment on 24th August 2017, upholding the fundamental right to privacy under Article 21 of the Constitution of India. It is stated that in the judgment that the privacy is to be an integral component of Part 3 of the Indian Constitution, which lays down the fundamental rights of the citizens. The Supreme Court also stated that the state must carefully balance the individual privacy and the legitimate aim at any cost, as fundamental rights cannot be given or taken away by law, and all laws and acts must abide by the Constitution. The Supreme Court also declared that the right to privacy is a decision that has been passed by all 9 judges, holds that the decision of the MP Sharma versus Satish Chandra, which holds that right to privacy is not protected by Constitution of India, stands overruled. And the decision in Kharag Singh versus State of Uttar Pradesh, to the degree that it holds that the right to privacy is not protected by the Constitution, also stands overruled. And the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 of the Constitution of India, and as a part of the freedoms guaranteed by Part 3 of the Constitution. Thus, after going through this judgment, it is very clear that the Supreme Court of India has once again, the convict is entitled to the precious right guaranteed under Article 21, and he shall not be deprived of his life and personal liberty except by the procedure established by law. The question of the right to be let alone again came on the front in the case of Rajagopal versus State of Tamil Nadu, as I have mentioned just now, which is popularly known as Otto Shankar case, popularly known. A prisoner had written his autobiography in jail, describing the conditions there and the nexus between the prisoners and the several IAS and IPS officers. He had given the autobiography to his wife so that she may publish it in a particular magazine. However, the publication was restrained in various matters, and the question arose whether anyone has the right to be let alone, and particularly in jail. In Rajagopal case, it was held that held to be implicit in Article 21. It is a right to be left alone as guaranteed by Article 21. So a citizen has a right to safeguard the privacy of his own, his family, etc. So it is very important here that the court in this case held that right to privacy as a right to let alone, and no one can publish anything concerning the above matters without his consent, whether truthful or otherwise, whether laudatory or critical. And here I must mention one thing, that so far the right to privacy is concerned, that I told you that we have seen very interestingly, recently, regarding the Pegasus spyware scandal, which created a hue and cry in all over India, in both political circle and also in public circle, regarding the Pegasus spyware case. And you see, in this case, we have seen that 12 petitions, were filed before the Supreme Court. And as you have heard about this, that many politicians, many individuals, even many judges, their privacy has been infringed by this spyware, and the Supreme Court here, we have seen that 12 petitions were filed before the Supreme Court for an independent proof into the alleged illegal use of Israeli NSO group spyware Pegasus, and which has violated the right to privacy of many individuals, including even politicians, opposition leader of the parliament, and also many people, big leaders, and also some ministers, cabinet ministers also we have seen. And so ultimately, then the bench of the Chief Justice of India, N.V. Ramana, Justice Suryakant, and Hema Kohli, they said that the petitioners have placed on record certain material and prima facie merits consideration by this court, and there has been no specific denial of any facts averred by the petitioner, by the respondent, and Union of India. Actually, very important to mention here that when this scandal came out and publicly, there was a lot of hue and cry, then the central government, the union government, took a silent, spectator like this, and there was no comment from the side of the central government. Neither they denied it, nor they accepted it. So they were just taking a middle path, and so you may take it for granted that they have actually used this spyware to, spying all the activities of the, opposition leaders and big other leaders, or you can also think that, they have not actually, central government has not, brought this, or central government has not used this. Now, because the government did not make any, comment on this, whether they have used this or not, and they have taken the plea that this is completely a matter of national interest, security. So in that case, the government cannot divulge anything, whether this side or their side. Now, on this point, of course, then ultimately the case, around 12 petitions were filed before the Supreme Court, challenging this attitude of the government, and to know whether the government has used this spyware for spying the opposition leaders and others. So as I told you that there has been no specific denial on the facts, averred by the petitioners, and by the respondent, Union of India. And so ultimately, then the Supreme Court, then we have seen that while acknowledging that it is a settled position of law that in matters pertaining to national security, the scope of judicial review is limited, the Supreme Court bench said that this doesn't mean that the state gets a free pass every time the specter of national security is raised. Because every time, whenever these type of issues are coming, the central government is taking the plea of national security. And so the Supreme Court is very clear in this case, that this doesn't mean that the state gets a free pass every time, the specter of a national security is raised. National security cannot be the bugbear that the judiciary shies away from. And by virtue of its mere mentioning, so although these courts should be circumspect in encroaching upon the domain of national security, no omnibus prohibition can be called for against judicial review. The mere invocation of national security by the state doesn't render the court a mute spectator. Just see the words of the Supreme Court, headed by the Chief Justice of India, N.V. Ramana, in this case. And it listed what it called the compelling circumstances that have weighed out with us to pass such a right to privacy and freedom of speech are alleged to have been, impacted, infringed, which needs to be examined here by the court. The entire citizenry is affected by such allegations due to the potential chilling effect of these. No clear stand taken by the government of India regarding action taken by it. And seriousness according to the allegations by foreign countries and involvement of foreign parties also is involved. And possibility that some foreign authority, agency or private entity also is involved in placing citizens of this country under surveillance, which is very dangerous. So, so the terms of reference of the committee include here whether the Pegasus suite of spyware was used on phones or other devices of the citizens of India to access stored data, eavesdrop on conversations, intercept information, and on for or any other purposes not explicitly stated therein. The details of the victims and persons affected by such Pegasus spyware attack. Then what steps and actions have been taken by the government of India, respondent government of India, after reports were published in the year 2019 about hacking of WhatsApp accounts of Indian citizens using the Pegasus suite of spyware. Because this, we have seen in 2019, there were a lot of, hue and cry about the hacking of WhatsApp accounts of very many Indian citizens by this Pegasus spyware. Now, whether any Pegasus suite of spyware was acquired by the respondent Union of India or any state government or any central or state agency for use against any citizen of India, that was also the question before the Supreme Court. If any governmental agency has used this spyware on the citizens of this country, under what law, what rule, what guidelines and protocol or lawful procedure was such deployment made? What was the authority of the government of India, by which it has deployed this type of spyware upon the citizens of India? So these all things have been, came for discussion before the Supreme Court. And during the hearing, the center had filed a brief affidavit unequivocally denying the allegations against it and said the matter involved national security questions, due to which it did not wish to put the details in a public affidavit and make it a matter of public debate. So it said it would diverse the details to a committee of experts who would examine the issue. And it requested the court to allow the central government to set up a committee by the central government. But the bench of the Supreme Court, in its order, said it is turning down the government's request to allow it to set up a committee due to allegations that the union or the state governments are party to the rights deprivation of the citizens. So it said allowing the request would violate the settled judicial principle against bias, that justice must not only be done but also be seen to be done, as we have studied in our administrative law. Now, noting it was an extremely uphill task to find and select experts who are free from prejudices, and then a committee, the have been set up by the Supreme Court of India to go through all these things. The ruling also touched upon the citizens of the privacy rights, noting certain limitations exist, but any restrictions imposed must necessarily pass constitutional scrutiny. The bench said the right to privacy is directly infringed when there is surveillance by spying done on an individual, either by the state or by the central agency. So here, what we have seen, that this is very important to note, that a committee has been set up to investigate the whole matter and give report to the Supreme Court about the Pegasus spyware, whether the government has given or any agency of India has used this spyware for surveillance over the civilians and leaders and all. Now, it is very important and necessary corollary of such a right is to ensure the protection of sources of information. Protection of so that is also very important. And ladies and gentlemen, here again I must tell another important point to you, that in very important judgment, SINGH versus Union of India, that was a very landmark judgment of the Supreme Court, SINGH versus Union of India, judgment delivered by the Supreme Court of India in the year 2014, where 66A of the Information Technology Act has been struck down as by telling that it is unconstitutional. But very interesting that in that judgment, in SINGH case, the Supreme Court, didn't struck down another important provision of IT Act, Section 69A of the Information Technology Act, which has been inserted by an amendment in 2008 to the Information Technology Act, Section 69A, under which the government of India has the right to, even block any social media or any, like WhatsApp or any media, it can block on the pretext of national security and sovereignty of India. And you have seen that a number of Chinese, social network has been, blocked by the government of India under this section, Section 69A of the Information Technology Act. So here the central government has got the absolute power, that in the question of national security, of course, here again, the question of national security and national sovereignty is concerned, then in that case, the central government has the absolute power to block any social network site whenever it thinks so. So this is also another provision where the central government has got the absolute power to do such a thing. And in the SINGH case, we have seen that Supreme Court did not strike down this Section 69A. Rather, only Section 66A has been struck down by the Supreme Court in that case. However, recently we have seen that the government of India and a joint parliamentary committee have proposed a draft bill on personal data protection, which will be India's first law on the protection of personal data, if it is passed by the parliament. Now, this personal data protection bill, it is pending before the parliament. And as I told you, that already Joint Parliamentary Committee has submitted its report. And now we are expecting that it may be, passed during this winter session of Parliament. But let us see what happens. And if this law is passed on personal data protection, then I think that will, of course, usher a new era in the field of personal, right to privacy in case of data protection and all. And that will be the first law in India on the protection of personal data, and which will repeal, of course, ultimately Section 43A of the Information Technology Act 2000. So now, after going through all these judgments, dear friends, I have tried to just give you a good idea about this right to privacy, how it has been incorporated in our Indian Constitution through judicial, interpretation, and also sometimes we can, describe it as a judicial activism, and by which, as I mentioned you, the latest judgment, Puttaswamy case, and which is, strongly argued that, right to privacy is a very much fundamental right, which is incorporated under Article 21 of the Indian Constitution. And it is, of course, true when we are talking of individual human rights. And then we must mention that until and unless we have that, right to privacy, no individual can, develop himself as with full development in the society. So with these words, now the floor is open to the participants, that if you want to supplement my discussion, then you can supplement, or you can also, if you have any confusion, you can ask me anything. So thank you very much for your patience hearing. And actually, this is very much important human rights issue. And we have really faced many times in India many issues like this, where right to privacy has become violated by different way. And now, of course, due to this latest scandal on Pegasus spyware, this issue again has come in front. And now let us see and hope the Supreme Court will take a very positive step for the protection of individuals' right to privacy and individual dignity and their human rights. Thank you very much. Thank you all. So if you have any supplement or any, thank you very much. Mr. Jogan, are you here? Dr. Y.K. Verma, are you here? Herbal Department?
Sir.
Okay, now floor is open.
Ramasankar, please give your feelings. Say your feelings. By your own emotion. आवाज आपकी नहीं आ रही है रमाशंकर जी. Your voice is not audible.
Sir, now am I audible, sir?
Yes.
आवाज आ रही है?
Sir, yeah. Can you introduce yourself?
You say something.
Yeah, you please.
My name
please.
Yes, sir. My name is Dr. Ramashankar, sir. I am from CM Law College, Darbhanga, sir.
Thank you.
Assistant Professor in Law, sir. Your speech was really very informative, sir. Starting from the beginning of privacy, you have concluded till the bill which is pending in our parliament.
Yeah.
But till date, no law has been passed in this regard.
Right.
It is very unfortunate, sir. I would like to discuss one more thing, sir. In the starting of the lecture, you have discussed about some incident in USA also, sir.
Right.
So I want you to discuss those things about Pegasus. I have heard all these things in news. Why this software has been used, sir. If you can discuss what was the case in USA about privacy. So you have told some cases about privacy.
You see, USA, there are a number of judgments, and they have also included this right to privacy as a fundamental right under US Constitution. Actually, I have not mentioned USA because if I want to mention, then I am to talk about other countries also, like China, and there are and many countries which have their own laws, and especially if we take USA and all, then yes, of course, I can mention some important cases also, US Supreme Court, like Boyd versus United States. That was a case of 1886, very old case of the US Supreme Court. Boyd, B-O-Y-D, Boyd versus United States. And, it initiated a broad interpretation of the Fourth and Fifth Amendments to the American Constitution in the context of criminal prosecution. And see, in 1890, in the Harvard Law Review, there was an article written by Samuel Warren and Louis D. Brandeis that privacy concept from its proprietary and criminal procedure history, right to be let alone, is the fundamental right of every U.S. citizens. And here, so the law gave a remedy only for physical interference with the life and property for trespassing, etc. Now, what happened? U.S. Supreme Court in Griswold versus Connecticut, that is a case of 1965. Latest case. Justice Douglas, in a classic exercise of judicial activism, found a right to privacy in the, that is first, third, fourth, and fifth, ninth amendments. And he mentioned that the threat to privacy in the Griswold was a criminal prosecution for use of contraceptives, but there were, so all people are by very nature free and independent and have certain inalienable rights, among which are those of enjoying and defending life and private right to privacy. So it soon became obvious that the privacy issue has been, made the central point of the U.S. Supreme Court judgment. There are a number of judgments I can mention where the U.S. Supreme Court.
Watergate scandal, sir. The Watergate scandal. It was also about right to privacy.
Yeah. So, there are a number of judgments, and also in USA, there are, like, I can mention some of the judgments also USA. That is a case of 1989. The Justice Stevens in Thornborough versus American College of O&G observed that the concept of privacy embodies the moral fact that a person belongs to himself and not to others, not to society as a whole. So it is individual interest in avoiding disclosure of personal matters and interest in independence in making certain kinds of important decisions. And it is absolutely its own. So there are a number of judgments, in America, of course. And one 1977 case, Kerry versus Population Services International. The Supreme Court was of the opinion that, American Supreme Court, that if the due process right of privacy under the 14th Amendment meant anything, it was the right of the individual, married or single, to be free of unwarranted governmental intrusion into matters so fundamentally affecting a person as a decision whether to bear or beget a child. So there are a number of judgments, in USA. And of course, recently, when the scandal, that has been flushed out by Snowden, Mr. Snowden, the former, official of the American National Security Agency. Then, of course, there were a lot of debates that in America, the American spying agency also, they are doing surveillance, in many countries for getting the private data of individual, like they are tapping private conversation of prime minister, president, and all, which is a complete violation of, national security and also right to privacy. So the debates then have been started that whether at all we can claim, in this age of highest technological development, the right to privacy. That is the main challenge now, because the technology has been so much developed, so advanced, that it is very difficult, to sometimes, even to just, get the hints that your privacy has been infringed by somebody. Okay, now, see, I'm just giving you an example because you have seen that, that when after the Nirbhaya case, when the Indian Penal Code has been amended by the Justice Verma Committee, JS Verma Committee, okay, in 2013, Criminal Law Amendment Act, under Justice J.S. Verma Committee, you have seen that voyeurism has been added, one of the offense. When anybody is doing something in his privacy, and if it is kept or recorded or taking snaps by anybody, then that is an offense under section, Indian Penal Code, section 300.
354C, sir.
Yeah.
354C.
Right. 354C of the Indian Penal Code as voyeurism. And you might have heard the very important, story of, that Smriti Irani, actually, who went to Goa with her husband, in a private tour. And she went to a mall to purchase some clothes. And while, she was using the, the room, for changing cloth, in every mall there is a secret room for changing the cloth, private rooms. When she was changing her cloth, all of a sudden she found a small light inside the room as a spying camera, which was just inside that, cloth changing room, and see, man, it's so dangerous because many of us are not aware of all these things. Many times we are going to mall, we are purchasing clothes and all these things, and whether these are, okay, fitted to us or, so we generally, go to the changing room, cloth changing room, and there, after closing the door, we think that we are secure, but at least, dear friends, we are not secure because, now, in many, all over the world, this is a dangerous thing. In many countries, in hotels, in malls and all these things, there are some, spying camera, hidden camera, kept in such a way that you don't know where it has been, hidden. Even inside the sofa set, small camera, and when you are changing your cloth or doing something, some sexual act or all this thing in your privacy, then they are taking the steps and all these things, and sometimes they are selling it as a pornographic act. So this is very dangerous. So that's why I'm telling that the technology has become so advanced. Now, really, I'm telling you, whatever law you make, I believe that very difficult to protect individuals' privacy. Always, all the time, in every place. Very difficult. Very difficult. Thank you.
Thank you. Thank you so much.
Madam Nutun Kumari. Madam Nutun.
I have a question, sir.
Yeah. Okay.
Good evening, sir.
Madam,
Sir, I'm
Madam,
Ruchi
first
Singh.
you introduce yourself.
Ruchi,
Yes, sir. Good evening, sir. I just have one question. It's a common question for all the professors here, like including our HOD sir and Virendra sir. What do you think about the minority opinion in Aadhaar case? Because this is not exactly on privacy, but on that part of constitutional transparency and the abuse of constitutional process, because that argument, especially of Justice Chandrachud, where he had talked of procedural ultra virus part of the law, that it was included, it was initiated as a money bill. I always never get I'm never comfortable with that part of the entire decision. So that's why I've raised this question, sir. It's not directly on privacy, but on that part of Justice Chandrachud's part.
Right. That is a very important, dissenting opinion given the Justice Commission.
Yes, sir. Because you raised that Kharaj Singh Subarao's opinion, which interested me. That's why I raised this question. So I was listening very carefully to the entire lecture.
Actually, really, because if we read that judgment, there Justice Commission highlighted certain areas because how this can be treated as a money bill and all these things, as you told, because the definition of money bill under the Indian Constitution is totally different.
Yes, sir.
So it can be treated like this. And number two, that yes, the decisions taken by the government of India that they are using this Aadhaar card for certain, public benefit purposes. No, when they are implementing schemes to the poor, they are using this. But it's very important that Justice Chandrachud rightly pointed out that central government cannot give the foolproof assurance that it will not be used for any other purposes. That is the main danger.
Thank you, sir.
I'm telling you that, you see, this is very important to say that all of us, what we see now, that Aadhaar card is being used in bank, insurance company and other things everywhere. Even when you are purchasing a mobile, they are asking for other details and all. And you don't know all this information, your private information, are being used for what purpose, where, you don't know. Very difficult. That's why there is that Aadhaar card, controversy is still pending. And we are asking the government, for what purpose they are using our personal data.
Ruchi ma'am, please mute your mic. Then we can hear sir very much clearly. Sir.
There is echo.
Yes, sir. There was echo, sir.
Yeah. Because
Now
I think
now we are
usually open the microphone maybe. Yeah. Actually, this is very interesting question, Ruchi. She raised the question, very interesting question, because if you see the minority judgment, very important. If you read the minority judgment of Justice Chandrachud, and Justice Chandrachud is a judge of eminence. He is very straightforward. Many judgments we have seen, Justice Chandrachud is very much updated and very straightforward. And really, I'm telling you that whatever now the position, still now, so for the other, that card is concerned, the privacy of your all information is still, I think, is under some cloud, whether you are at all, there is any guarantee by the government that they're not using your, all this private information for any political purpose or other purpose.
Thank you, sir.
Thank you, Ruchi. Thank you very much. Actually, this is an issue now. Thank you. This is an issue actually. What we can discuss, hours and hours, because as I told, that see, technology is so advanced now. Now we are going to get a new law. We are expecting that anytime the Parliament may pass this law, Personal Data Protection Act, at least which can be somewhat helpful, which can help us to secure some data at least in internet and all. But you see, I'm telling you, whenever you are searching in internet, then you will find cookies is there, cookies. And you have to accept that. And once you accept that, then be sure that your everything is going to the public. And how many people, how many of us know this? We are allowing the cookies. No. So that we are getting the all information. By that way, you are divulging, your all personal information to the outside public. So now, what happened now in this age, now many people are using internet, thousands and thousands of people, they are now accustomed to this, Android, mobile phone and all these things, they are using many social sites, and very dangerous that if you are not very careful, anytime there is every chance that your privacy is divulged to the public. And many times I have seen that when I'm going to mall, purchasing one shirt, I'm asking the, then in the counter, the boy was asking me, sir, आपका mobile number बोलिए. Why do you need my mobile number? नहीं सर, हम लोग का नहीं तो आपका बिल नहीं बना पाएंगे. क्यों नहीं बना पाओगे? और मोबाइल नंबर से तुम्हारा क्या मतलब है? I have paid the money. You give me. But they are arguing for keeping the mobile number of the customer. You see, when you are purchasing, you are giving the bill and asking you for your mobile number. So these are very dangerous.
So here's a question, sir.
Yeah.
Sir, regarding Corset ID, what should be our options? Should it be for everyone or for a restricted person or for only oneself? Corset ID, sir.
Please repeat again.
Madam, introduce herself first.
Sir, ORCID ID, ORCID ID. Sir, it should be for everyone or for oneself only, limited to oneself only. Sir, just wanted to whether it comes under the paradigm of right to privacy or not. So here we are having academic achievements. So what should be the option? Should
Actually,
it for every?
that is the again another question you have raised, very serious question actually, and I think that it is not for everyone. I don't think.
Madam, please introduce herself.
I have restricted to myself only, but the option is there.
Yeah, option is there. You should not give it to the public.
Nutan ma'am, please introduce yourself.
Okay, sir. So it's me, Dr. Nutan Kumari, an assistant professor, Department of Political Science, TPS College, Patna.
Oh, thank you, ma'am. Nice to meet you. Yeah, thank you, ma'am. Thank you. I'm very happy that even teachers from political science, yes, because this is a part of also social science, no? Law,
Yes, sir.
political science, these are all part of social science. So it is good that you are attending this literature course because then we are many topics which are very related to this.
मैं चंद्रभूषण श्रीवास्तव, कॉलेज ऑफ आर्ट्स एंड क्राफ्ट्स, असिस्टेंट प्रोफेसर, पेंटिंग डिपार्टमेंट.
Okay. Thank you, Professor Srivastava.
Yes.
So, are you getting interest in all these human rights aspects?
Pardon, sir?
Are you getting interest in hearing all these?
सर मैं तो फर्स्ट टाइम ह्यूमन राइट्स का ये रिफ्रेशर कोर्स किया और
आपको कैसे लग रहा है?
बहुत अच्छा लगा, अलग अलग उसमें, और पेंटिंग्स के साथ भी हमने जोड़ा इसको, तो बहुत अच्छा लगा कि ह्यूमन राइट्स का इतना ब्रॉड वो है,
राइट
एरिया है. जी
एक्चुअली देखिए, मतलब ह्यूमन राइट्स, if you define human rights, then all the rights what we need as a human being for our survival in the society, all these are human rights. So there is no end. There is no end. Okay, every right, whether your right to food or right to work, whatever you think, right to privacy, all these things are coming. And if you see Article 21 of the Indian Constitution, now since 1960s till today, 2 judgments given by the Supreme Court, and many important, many rights, human rights, have been included within the purview of Article 21 as a fundamental right. And so now Article 21 has become itself a mini constitution. Article 21. So many things have been included. So many rights: right to education, right to shelter, right to food, everything now has been included by the judgment within the purview of Article 21. So now Article 21 has become itself a mini constitution.
Kumar Patel.
हाँ सर, myself कुमार पटेल.
Yeah, thank you.
डिपार्टमेंट ऑफ साइकोलॉजी, महाराजा कॉलेज आरा. आपने तो बहुत अच्छा सर वो ह्यूमन राइट्स के बारे में बताया. बहुत बहुत धन्यवाद सर आपको. बहुत बहुत थैंक्स.
Dr. Bandana, are you hearing my voice?
खत्म हो गया.
अभी खत्म हुआ.
Dr. Bandana.
It is good that actually PG Department of Law, Patna University is organizing such an important refresher course. Actually, human rights for all. और मुझे अच्छा लग रहा है कि जो भाई साहब आरा से आए हैं, पटेल साहब, और जो आपका श्रीवास्तव साहब हैं, they belong to different department. Madam Nutan Kumari belongs to political science. Anyway, political science is a part of our legal fraternity. We treat you as our part of law. Okay, but you see, Professor Srivastava is there, then Patel is there, those who belong to other stream. It is good that they are participating in this program where many issues relating to human rights, are being discussed. And that will give you complete knowledge on human rights and all the rights you need and how to utilize that right. Okay. The only thing that we are to, but we should not forget about duty also, human duty. Because rights and duties are very much correlated. And see, when we are talking of human rights, then this is an Western concept, because we are talking about only rights, but our Indian concept is based on duty, human duty, and dharma, which is called dharma, Raja Dharma. What is the duty of the king? Okay, my dharma, my duty to my wife and my children, my duty to my society. So Indians, they believe in rather duty than the rights.
Thank you, sir. Thank you so much, sir.
So thank you, Jogan. I'm very happy that you have given me the opportunity to discuss this very important issue among all my colleagues. Those are all our colleagues, my colleagues. Though I'm an old man, but still all are my young colleagues here. So I'm very happy that I got this opportunity.
On behalf of department and participants, some word will be said by our elder brother, Dr. Biren Kumar Gupta.
Yeah, Birenji.
Ji, sir. Thank you very much, sir. And thanks a lot for this wonderful speech on human rights, very sensitive issue of human rights. And I think participants have learned a lot from your speech, sir. And I only like to say, in the regard of Professor Chakravarti, that while citing an example of America, he has well said about a conflict between empiricism and positivism. And dear participants, it is always said about law that it is a common sense of a statesman. Today I will say that you have heard a statesman's view, which is perfectly a dominance of law, a spirit of law upon the letters. And with that, thank you very much, sir. Again, we are very much enlightened by your speech, sir. Thank you very much.
Thank you. Thank you. Thank you so much.
Thank you, sir.
So, thank you.